Hearing the appeal, Roger Watson against the King.
Mr. Taylor, we're grateful to you and your juniors for your written submissions. We'd like to get Pennington Benton first, please.
My Lord, yes.
Good morning, my Lord. Yes, I thought that might happen. Respectfully, my Lords, in respect of grounds 1 and 2, I effectively make one submission. And it is as follows. I respectfully submit that the Court of Appeal did not breach the appellant's right to natural justice by neglecting to give fuller reasons than the reasons it did, nor by neglecting to hear submissions from counsel on sentence, or alternatively that these failures, if they were failures, are not fatal to the decision to impose the sentence it did. And in either case, I make that submission for essentially 6 reasons. The first is that the trial judge had already considered in detail the nature of the offence committed, the aggravating and mitigating factors, and all relevant submissions were made on those on the appellant's behalf. Sorry, it considered all relevant submissions made on the appellant's behalf in these respects. That's the first point.
You considered the offence to be murder, rather than
Indeed. Indeed. The second point is that the judge gave full and cogent reasons for finding that the appellant's conduct fell, quote, within the upper range of the spectrum of criminal culpability for murder, end quote. 656. 3. The judge held the appropriate sentence to be one of death, but he could just have easily have said life imprisonment. The key point, I submit...
It was Dame Anita Allen, I think.
She. Yes. Sorry. I did go all the way through my speaking note, correcting all the he's to she's, but I obviously missed out. But anyway, the key point is that she gave cogent reasons for finding that the culpability of the appellant stood at or near the top end of the scale. 4.
Sorry, I thought that was your second point.
In other words, the judge imposed the sentence of death, but it could just as easily have been a sentence of life in prison. It wouldn't make any difference for the purposes of my argument. Because the important point for the purposes of my argument is that the judge gave cogent reasons for finding that the culpability of the appellant for the homicide was at the top end of the scale. Point 4 is that the Court of Appeal quashed the conviction for murder on the basis that the judge was wrong to direct the jury that reckless killing was or may be sufficient to establish intention, or what might be referred as constructive intention, for the purposes of Clause 12.3, which of course your Lordships are familiar with. 5th, and crucially, the judge must, however, in my submission, have sentenced on that basis, i.e. on the erroneous basis. That constructive intention or reckless disregard was sufficient to infer intention. But the point there is that the culpability identified by the judge and the gravity of the culpability identified by the judge.
Well, the judge sentenced on the basis of intention.
Well, I'll come to his sentencing remarks in a minute, but in my respectful submission, that's not quite
Well, to
the
be
end of the story, because the judge sentenced on the basis of a full understanding that this wasn't a specific intention, it was intention based on a reckless disregard, and that was the error. The point is, if the judge sentenced, if the judge's sentencing reasons are predicated on a proper understanding of the actual mens rea of the appellant, namely reckless disregard for life, he then applies that sort of moral culpability finding to the scale of sentences available for murder. The Court of Appeal, this is point 5, sorry, this is point 6, the final point, the Court of Appeal is entitled, I respectfully submit, to effectively transfer across those reasons and those findings of moral culpability to the new offence. Now, if the judge, that's the 6 points effectively. Now, my lords, if the judge had sentenced on the basis that this was a case of specific intent, which is a common law approach to intention, and said, well, look, okay, this defendant intended to kill this child with the bullets he fired into the house, or somebody else, and transferred malice applies, then the sentencing reasons couldn't be applied across. But the whole point of the Court of Appeal's judgment, effectively, is to say, well, the judge proceeded on the basis that reckless indifferences to injury was enough to establish intention, but that's also the basis on which the judge sentenced. So all that's happened is the Court of Appeal says, well, you've applied the right, you've reached some perfectly, you've reached some perfectly cogent reasons as to where this appellant's moral culpability lies on the scale, and you've correctly identified those reasons by reference to his callous and disregard for human life, not specific intention. But what you've done is you've applied those findings to the wrong chart of sentences, effectively. You've applied them to the wrong scale of available offences, but that's the only error that the judge has committed, effectively.
The wrong scale?
Yes. So rather than saying, okay, so the judge proceeds on the erroneous basis that reckless disregard for life is sufficient to establish some form of inferred or constructive intention. He sentences on that basis, and on that basis he says this is a really, really serious offence at or near the top of the scale. Yes, for murder, but on the basis that murder includes this sort of mens rea, when in fact it doesn't. The Court of Appeal says, well, actually, you're wrong about that, because this is, in fact, a manslaughter case. However, there's nothing wrong with the judge's reasons that the mens rea that she understood to have been established by the jury made this a very serious case, up or near the top of the scale. So,
should Mr. Watson not have had the opportunity to address the court as to where this offence stood in the scale of penalties applicable for manslaughter?
Yes, I accept that should happen. And I think it was accepted by counsel for the respondent in the Moss case, that should happen. But I do submit that if I am right, and I accept your lordships may or may not be with me on that point, but if I am right, that the judge sentenced on the basis of a proper understanding of the actual mens rea that had been established, then the reasons, if I'm right as a consequence of that the reasons can be transferred across, then the procedural irregularity falls away, because the appellant has already had an opportunity and did already make submissions on questions of aggravating factors, mitigating factors, mens rea, and all the rest of it before the trial judge. There was
but not in the context of the scale of appropriate penalties for manslaughter.
Correct. But if I'm right, and it's a piggyback argument, I accept, but if I'm right that the judge's reasons for identifying the moral culpability of this appellant for effectively for a manslaughter offence, although the judge applied the wrong offence to those findings of culpability, but effectively the judge has already said, this is your moral culpability, these are all the reasons why I say this is a terrible case, callous disregard for life, etc. In other words, if it's accepted that this case falls at the top or near the top end of the scale for homicide, then you don't get the opportunity, effectively, I say, to have an opportunity to say to the Court of Appeal, well, I should only get a determinate sentence of this level because my offending falls at this level of the scale, because the trial judge has already decided for the reasons that he gave that your offending is at the other end of the scale. And the Court of Appeal...
For sentencing, there is no single scale in relation to homicide.
No, I'm talking about a sort of... I'm not talking about the range of available sentences so much as the range of moral culpability. You have, in other words, you could have many manslaughter cases are, of course, accident cases.
But Mr. President, I'm puzzled by this. I think the essence of your submission is that the fact that the judge misdirected the jury on the relevant intention tests for murder had no impact upon the judge's assessment of the moral culpability of what had been done.
Yes.
But isn't the fact that the law of Jamaica makes a fundamental distinction between murder and manslaughter along the basis of whether there is intention on the one hand or recklessness on the other hand, fundamental to moral culpability?
It is the offence.
It's not some technical distinction.
Oh, no,
The difference between murder and manslaughter.
Oh, my Lord, I completely agree. It's in the Bahamas, an intention to kill is required, as opposed to in England, as your Lordship says, intention to cause GBH is enough if death results. Yes. And obviously anything less than an intention to kill is a manslaughter case. But my point is that the judge, the criticism of the judge, and indeed the reason why the conviction for murder was set aside is because the judge proceeded on the basis that the mens rea for murder was the mens rea for manslaughter. But he also sentenced on that basis.
Yeah.
So in other words, the judge didn't say, this is a case where you deliberately and intentionally set out to kill this child. That's a dreadful case. Therefore, you're punished at this level. So in other words, the judge effectively did punish him for manslaughter.
I find it very hard to understand that because the judge was duty-bound to be faithful to the jury's verdict, and the jury's verdict was intention to kill. And so the judge must have sentenced on the basis of an intention to kill.
I think my point, Mark, is there are different types of intention. I mean,
but it still ends up as being an intention. The judge incorrectly said you can assume that there is intention from recklessness.
Well, it may be worth just, in that regard, turning up the sentencing. Can we just turn up some of the passages, my Lord, from the sentencing hearing and then the sentencing decision? I promise not to take very long, but I think it was well. We just start at 578 of the electronic bundle. So there's several adjournments in order to get together some psychiatric evidence and other things. So I'm at page 578. So,
I've got a problem, I'm sorry. Yes, thank you.
so my lords, this is where the Crown's submissions start on the sentence, and if we just go over the road onto page 579, the Crown is always seeking death penalty in this case, and at page 580, lines 13 onwards, the evidence is summarised from Dr. Raju, the forensic pathologist, explains the cause of death, and at the bottom there, pages at lines 26 and onwards, talks about the effect of being hit by these bullets, and also if a bullet passes through an intermediate structure before hitting the body of the target, that it can cause additional damage. Over onto 581, lines 18 to 23. He opined that the firearm was possibly a .223 Remington. He stated that this firearm could penetrate a wooden wall. He indicated that a .223 Remington is a type of rifle, has a shooting range of a mile and is a powerful round. As your lordships know, it was discharged multiple times at close range into a wooden house where the deceased was found. My lords, I can skip on then to page 585. The case of Patrick Ray's was cited at lines 19 onwards. And at the bottom at line 31 onwards, the crime may be human and understandable, calling for more pity than censure, or brutal and callous to an almost unbelievable degree. I may have occurred much in the heat of passion, etc. Murderous intent may be unmistakable, or it may be absent. And what the court then interjects at line 10 to say, in this case you're suggesting that the motive was revenge. And then Crown Counsel says, yes, my lady, I'm suggesting that the crime was premeditated. I'm also adopting from that portion of the judgment that it will be brutal and callous to an unbelievable degree. He talks about homeowners, home invasion, and all the aggravating features of this case, including firing a high-velocity firearm into the family home multiple times. And then over the road on 587, at line 4, we submit that everything about the facts of this particular case indicate the coldness and precision with which this particular convict carried out this act, shot up a home that he knew contained residents. I'll come back to that in a moment, because Court of Appeal's judgment, of course, is he didn't know.
Yes.
We can't assume that he knew. Then, this is really the crux of the point, the judge interjects at lines 21 onwards. Is there a difference, she says, between a case such as this, where the victim is not in the convict's sight, for instance, the act of shooting a high-powered rifle through a door, is there any difference between that and the person who has his victim in his sight, knows that it is a young child, deliberately fires a rifle at him? What's the difference in terms of the degree of culpability? The response doesn't really take the matter further, so I'll just ask your lordships to turn to 589, when the judge sort of puts the question again. So I'm on page 589 at line 19. I understand that. I'm just asking whether the fact that it just seemed to me that if you, for instance, have your victim in sight, it's a 12-year-old boy, and you take a high-powered rifle and you shoot that person, is that more callous and more cold than if you don't know whether anybody is in there and you shoot into a house? And then we can pick up the conversation, the exchange.
Passage on 588 at line 10 to 14 might be relevant to your submissions, where the judge expresses herself of an understanding of what the jury have found.
Yes. That's a given, that in order for the jury to have convicted The question, of course, my lords, I can't now remember which of your lordships was in the case that recently dealt with section 12.3 from the Bahamas. I believe my Lord James
I was.
Yes,
Lord Lloyd James. Sorry?
I was, and I think Lord Stevens.
Yes. And the question, I suppose, is whether whether section 12.3 of the Penal Code is there to assist the jury. Not that it does a very good job of that, but if it's there to assist the jury to find intention, which I think is what your lordships concluded in that
Miller,
case,
yes.
or whether it is a form of constructed intention, in other words, whether it establishes substantively this is what intention means for the purpose of the Penal Code. And that's, I think, where the judge was going.
We said in Miller that it was a means of addressing the evidence.
Yes, that's right. But I think in some cases, and this is one of them, reading it literally, section 12.3 basically says, well, look, if somebody does something which with due caution they would realise would create a real risk of death, then you can presume intention. So read literally, 12.3 effectively creates some form of constructive intention. So yes, it is true, the jury must be presumed to have found intention, but on what basis?
And my follow-up point to that is that the judge must then sentence on the basis of intention.
Yes, but intention proper, or intention that she understands has been arrived at through reckless disregard. In other words, the judge sentences fully conscious of the fact that she's sentencing on the basis of a constructed intention. I'm going to come to that in a minute. So page 590 at the bottom of page 29, line 29 onwards. Crown Counsel says, I understand what your ladyship is saying. I'm not sure he does actually, but anyway. I would submit that it is equally callous. I'd submit that it is equally callous in what your ladyship posited to me, not knowing if the victim's there, not knowing if you struck them, that this convict knew that there were victims in there, ... The court, but there's no evidence that he knew. Obviously, there is an inference that he must know, or he is taken to have known, that if you fire into the home when people are likely to be there, then there is that inferred intention if someone happens to be there and you kill them. That is the legal position, the intention. In other words, the judge has not persuaded herself on any basis that this is a case of actual intention, specific intention. She completely understands that this is a case of effectively artificial constructed intention.
And she shouldn't have sentenced on that basis.
Sorry?
And she should not have sentenced on that basis.
But the fact that she did means what you actually have is a set of perfectly decent, cogent reasons from the trial judge, who's in the best position than anybody to understand what really was the moral culpability in this case, on the basis of that proper understanding of what the mens rea was. I know it's not a straightforward submission, and no, can I just take the lordships to one or two further references just to see if I can make good this point? We deal with the aggravating factors at page 604 and 605. Unprovoked attack on a family residence. Lacked remorse. Choice of his weapon was an indication of what a heinous and callous act it was. Rifle-type firearm, multiple shots into a wooden structure. Then, I'll just ask your lordships to turn to 623. Further exchanges between the bench and counsel for the Crown. I'd like to pick it up at line 10.
Sorry, page?
623.
Thank you.
Thank you. Line 10, the circumstances of the case is what I'm having a problem with, and whether in fact, this again, this point about the victim being in sight. And then I think the most probative parts are then on page 624, lines 9 to 16. I know this isn't very good for the audience, but I can't keep reading them out, so I'll just ask your lordships, if you don't mind, to read 9 to 16 and 24 to 32 on that page.
Nine to 16 and, sorry?
24 to the end of the page.
Thank you.
The judge is there effectively talking about the risks associated with the conduct. And then on page 625, at line 28 to the end of the page, 625 over the next page, line 28 to the end, somebody has to be home, people at home bathing, having supper, etc. Over the page onto 626. All of 626, but I'll pick it up orally, if I may, at line 14. You know, Mr. Watson, it is a very serious thing to take a high-powered rifle and shoot into a dwelling house at 8 p.m. in the evening. The chances that somebody is there and will be killed is very high, very high. Who could be so silly at 8 p.m. not to think that somebody may be in that home? It's not an abandoned home. It's not a business place at 8 p.m. It's a dwelling house where people go after school, after work for peace, quiet and relaxation. If you fire a high-powered rifle or any fire into a home, it is more likely somebody's going to be hit, etc. So the judge is dealing with this. We now know wrongly, as it were, because the Court of Appeal says it's wrong. But the judge is dealing with this basically on the basis of fully understanding that this is a reckless disregard for human life case. And then we can pick up the sentencing.
Yeah, your point essentially, as I understand it, Mr. Benton, is that the judge fully understood that the state of mind of the appellant was one of recklessness.
Yes, and had fully consumed, as it were, the facts of this case, which then fed into her later sentencing on that basis. This was all about. This is not an accident-type manslaughter case, and we'll come to that in a moment, but there are a lot of elements of the offence that, of course, are intentional and deliberate. He intentionally got dressed in camouflage gear, got himself a rifle, high-powered rifle, and deliberately, and I would respectfully submit callously, fired bullets into a family home, sprayed multiple bullets into a wooden home. All of that's deliberate, intentional. The only point that isn't legally intentional or deliberate on the Court of Appeal's analysis is whether this child was intended to be killed by those acts. But the judge is fully constant with that. That's the basis upon which the best person in the room to make an assessment of culpability, moral culpability, made the assessment of moral culpability. Well, to just pick it up in the...
but on the basis of a misapprehension as to whether that level of behaviour under the law of the Bahamas constituted the defendant a murderer. Or
exactly. And therefore opened up the chart of sentences, as it were, available for murder. But my point is to conduct a thought experiment, assuming that the judge didn't make 2 + 2 = 5, and said, well, actually, on the basis of all this is a manslaughter case, would her reasons for saying that this stood at the top end of the scale for manslaughter have been any different? My respectful submission, of course they wouldn't. Because the judge had already decided that this stood at the top end of the scale for murder cases, knowing that this wasn't a specific intention case.
And what's the scale for manslaughter?
Well, I'll come to that in a moment. It's life.
What's the scale for manslaughter?
Well, 1 year to life. There is no guidance, manslaughter sentencing guidance.
Literally no sentencing guidance whatsoever.
Correct.
For manslaughter.
Correct. There's one case that is sometimes cited as a case for guidance, but there's a decision of Sir Michael Barnett.
How do you have consistency between different offenders if you have no guidance for manslaughter?
Yes, well, that's no doubt could be the subject of a separate appeal at some stage. I think the answer is you look at previous sentences and you try and fit them somewhere within or outside of that range. But there isn't an official sentencing guidelines case that's being held by the Court of Appeal by majority in the case of Gray. But I do accept that when it comes to determinate fixed term sentences, my learned friend has, or somebody has on his team, gone to the trouble of reviewing lots of cases and have come up with basically a range between 18 and 30 years, I think. And this obviously, even if one takes off the 2.5 years for time on remand, this is a 47.5. So it's 17.5 years above the longest fixed term sentence that has been, to our knowledge, considered by the Court of Appeal. There may be first instance decisions, I don't know, but it should be 17.5 years longer than the longest fixed term sentence that has been imposed or considered by the Court of Appeal in the Bahamas. But there are cases, obviously, where life imprisonment has been imposed. Whether one views life imprisonment as a worse punishment than a fixed term of years depends on if somebody's reduced their sentence by 1/3, for example, I say 47, I think would turn to 33. So if the offender's 30 at the time of sentencing, probably not a whole life imprisonment. So one can then just turn to the sentencing judgment itself, which is at page 653. I'll just ask your lordships to read that page. Then there's some mitigating factors, or potentially mitigating factors, submitted to the judge on the next page at 654, instantaneous death. It was disputed that it was a home invasion. There's no frontal attack on the victim. The victim wouldn't have seen, in other words, their killer. Just a word of caution, my lords, in respect of paragraph 9. The correct assessment of the bullet is at paragraph 4. The judge can't, in my submission, have meant anything more by special bullet other than the fact that this was a .223 caliber, i.e. quarter-inch caliber, high-velocity bullet fired from a rifle with a high muzzle velocity capability of firing to mass at 1 mile that was used at close range. And that's all the judge means by special bullet. It wasn't a bullet that was designed to explode when it impacts upon a human being. And I think my learned friend rightly pulls me up on that point, and he's right. Well, they're right, sorry. Then we can turn to 655. And paragraph 13. Having considered that the victim was an innocent child, a firearm was used in the commission of the offence. The offence was as a result of an assault I consider a home invasion, that the convict deliberately and callously stood in front of and fired into the home, reckless as to whether anyone was at home at the time and not caring who was hit. No remorse, etc. But it's that sentencing remark there that again clearly shows the judge found this to be within the upper range of the spectrum of criminal culpability, except for murder, on that understanding. In other words, on the understanding that that sort of mens rea was sufficient to be a murder case. Doesn't matter, I respectfully submit, that the judge is wrong about that. Neither does it matter if the judge was wrong imposing the death penalty, as opposed to a life sentence. All that matters is when the thing is picked up by the Court of Appeal, plainly they have read and understood the case, and the Court of Appeal, unanimous on one point, that this is a case that falls within the upper range of culpability for manslaughter. So it's necessary then just to pick up the judgment of the Court of Appeal.
Yes.
Probably pick that up at 706, please, 706.
That's 35. The point is, sorry, paragraph 35 at 704.
Yes.
The point is made about the requirement of an intention to
Yes.
kill being essential.
Yes. I mean, not that, well, perhaps it doesn't matter, but I mean, one view that perhaps prevailed for some time was, I think, in some quarters, was that although there is a requirement, because it's unusual for the penal code to obviously create an offence that is different to the common law. I mean, many of these penal codes simply reflect the common law. But I think one line of argument was that perhaps section 12.3 combined with the specific intent ended up looking something like the law in England, because though there's an intention to kill, when you apply the watering down provisions of 12.3 to that intention, actually if you intend to cause GBH but death results and it's a reasonable probable result, then you end up, anyway, it doesn't matter, that ship sailed. The law is specific intent. 12.3 can't be used to create some sort of constructive intention, and therefore it was insufficient for the judge to say effectively that a great risk of death is enough to establish intention. And on page 707, 4 lines down, there is no evidence that the light from the television set could be seen outside, etc. We cannot say that we're satisfied that the direction on intention was adequate in the circumstances, etc. And then 2, 3, 4, 5, 6, 7, 8 lines from the bottom. In addition, the direction appears to indicate that recklessness as to whether death occurs or not is sufficient to support a guilty verdict for murder in the Bahamas. In those circumstances, the direction would be a misdirection. So the only reason I'm taking your lordships to any of this, and there's some further material at page 714, paragraph 43. The jury must have been confused into believing that recklessness is not caring whether or not someone was in the building was sufficient to found a conviction for murder instead of manslaughter. And then at 45, for the reasons given, we would allow the appeal, quash the conviction for murder, set aside the death penalty, and substitute therefore a conviction for manslaughter and impose a sentence of 50 years with effect from the date of conviction, because in our judgment, on the scale of manslaughter, the offence stands at the top end. Now, there's no reference there to the reasons of the judge, but in my respectful submission, that must be the basis upon which the Court of Appeal is proceeding. And they must be proceeding on the basis that they don't need to go back into all of those reasons, because they are good enough to justify, for all the reasons the judge gave, that this offence stands at the top end of the scale of manslaughter. The top end of the scale of manslaughter is life imprisonment. What, of course, I accept the appellant didn't get is, well, okay, even if everything the judge said was right, well, scrap that submission, let me start again. What nobody could have expected the Court of Appeal to do, in my respectful submission, is to go back over the same ground as the judge to get probation reports or psychiatric evidence and reassess all of that stuff that the trial judge had already done. So all the Court of Appeal would have done, in my respectful submission, as a resentencing hearing anyway, is to say, well, look, why can't we start from all the material that's before the judge? We can. What's wrong with the trial judge's conclusions in terms of moral culpability? Well, in the general, nothing. Can we fault the judge for saying that this is an offence standing at or near the top of the scale of criminality based on her misconception of the mens rea requirement for murder? No. Well, we take the same view as the judge for the reasons she gave implicitly, and there you end up with a sentence of 47.5 years, 33 jail years. My respectful submission that on the peculiar facts of this case was not an error, or not one that vitiates the sentencing decision of the Court of Appeal. At 727, one has the short additional comment by Justice of Appeal Longley, who dissents on another point, but on the question of sentence.
Page?
727. This case is at the high end of the scale. The only reason no one else was killed was a matter of pure chance. I was going to just very quickly turn up the decision of Moss, which is at 1047, 1047.
I'm so sorry, I think I misheard your page number.
1047.
Thank you, I did.
Thank you. That's the head note there for the facts.
Yeah.
Yes.
and I'll just pick it up, if I may, at paragraph 3. There had been some evidence that Moss was drunk. So this is Moss's appeal. This might possibly have been relevant to the question of whether Moss formed the specific intent required for murder. However, the judge had omitted to deal with that possible relevance. It was on the ground of this misdirection that the Court of Appeal quashed Moss's conviction for murder, together with the death sentence, and substituted a conviction for manslaughter, but didn't invite submissions and didn't hear submissions. That was said, as your lordships know. I'm not skipping over these sections, I just know that your lordships have seen them, but that was a serious breach of procedural fairness. And then I'll just invite your lordships to turn to 1051, paragraph 8. The board accepts the submission of Mr. Rowe, etc.
And you say this case is such a case, do you?
And it's important, my lord, yes, at paragraph 9, to recognise the board is satisfied that the present case, the Moss case, was not such a case. The defendant was and is entitled to address the proper factual basis for sentence now that the conviction for murder has been quashed. Because, of course, the proper factual basis was Moss may have been drunk. And then he's entitled, secondly, I say, to address the proper, and this is my Lord Stephen's point, is entitled to address the proper tariff for manslaughter, the proper place within that tariff for the present offence, and the effect of his lack of previous convictions, etc. But in my respectful submission, you have to read the second sentence with the first. It's the proper place within the tariff for manslaughter, based on the new facts. There are no new facts here.
But there's no tariff, you say, as well.
I'll come to that point in a moment, but there is no new. The important point for present purposes is there are no new facts. The judge did sentence on an understanding of the proper factual basis. And those reasons could just be transferred across. And it's not inconsistent with what is said in Moss. In terms of sentencing range, my lords, the most relevant case is called the case of Larry Jones. That's at 1101. And your lordships will see at paragraphs 1 and 2 that this judgment of the Court of Appeal considered those cases where defendants had been sentenced to the mandatory death penalty, but that was commuted or quashed, and then the question of resentencing arises. And the Attorney General, I think, appealed 2 sentences saying they were too light. Anyway, the point is, well, first of all, paragraph 81104, Appellant has prescribed a punishment for a particular offence. The prescribed punishment has been accepted by the judges as the maximum sentence which may be imposed on conviction of that offence. The maximum penalty is usually reserved for the worst cases. So in the case of manslaughter, the highest punishment available, as it were, or the harshest punishment available, I should say, is life, and that would be reserved for the worst cases. This case actually concerns resentencing for murder, but what the Court of Appeals say at paragraph 15. On the other hand, it must be noticed that over the past... Sorry, I should preface that by what's said in the previous paragraph. There are no statutory guidelines. On the other hand, it must be noticed that over the past 7 years, this court has set guidelines in respect of persons convicted of manslaughter. Pausing there, no, it hasn't. Sentences passed or upheld by this court during that period range from 18 to 35 years.
Isn't that the Court of Appeal saying that the sentencing range is 18 to 35 years?
It's the Court of Appeal thinking it's saying that. And then if we turn to page 1125, we have the case of Gray.
1125.
1125, my lord, thank you. And this is actually, again, a challenge, an appeal on the basis that 7 years imprisonment for manslaughter was too lenient. The appeal failed, but in the course of that, Sir Michael Barnett, President of the Court of Appeal, at page 1129, considered sorry, 1130 at paragraph 8, 1130. Paragraph 8, in essence, the Crown's appeal rests squarely on the efficacy and authority of the range set out in the decisions of the court in Larry Raymond. And then we can pick it up again at paragraph 15 at 1139. To properly assess the Crown's challenge to the sentence, it is necessary to consider the legal impact of the judgment in Larry Jones, etc. Paragraph 16. The court used that opportunity to give guidance to the lower courts on the proper range of sentences for persons who had been convicted of the heinous and depraved offence of murder, not manslaughter. At paragraph 19, I regret that I do not consider that paragraph 15 of Larry Jones has the authoritative effect of preventing the trial judge from imposing a sentence that is below the 18 years without exceptional circumstances. And I say it must also follow above 35 years, which was the other end of the scale identified by the court in that case. And then for the reasons in 21 to 23, the President explains why the range is a range of sentences that had in fact been imposed and considered by the Court of Appeal, but that did not make a guidance. That did not make guidance. Certainly not guidance that had to be adhered to unless exceptional circumstances were shown. So you're back to 1 year to life. I should just say, I don't want to take up your Lordship's time with it, but this decision was a majority decision with the Chief Justice dissenting. But it was then considered again in the decision called Ashley Heald, H-I-E-L-D, and that's at 1875. There's only one point that I would have taken your Lordships to, those paragraph 70, just accepting that actually there isn't a guidance case that says the sentence for manslaughter is between 18 and 35 years.
Ashley Heald, 1875 at paragraph?
70.
17.
70.
70.
Sorry, I should just one thing, because it would be remiss for me not to do so, and I don't want to cause my own friend to have to do it. But at page 1108, this is back into the decision of Larry Jones. I neglected to take your Lordships to it. Paragraph 17.
Sorry, we're going back to one...
You're back now to 1108. I'm just going back to the decision of Larry Jones because I forgot to take your Lordships to one paragraph. And what that effectively says is the range of fixed-term sentences for murder should be from 30 to 60 years. And then the last sentence, such a range of sentences would maintain the proportionality of the sentences for murder when compared with sentences for manslaughter. So I think, to be fair to my learned friend, because you may or may not need to hear, but to be fair to my learned friend, I think what he says is, well, guidance or not, what you have is, in fact, as far as we can tell in the Bahamas, fixed-term sentences for manslaughter don't tend to exceed 30 or 35 years. There's a couple of cases of life imprisonment, but that's all we were able to find.
So
and therefore,
in fact, for manslaughter, the top of the range is?
Well, I think it says 35 years in Larry Jones. I think my learned friend couldn't find one above 30 years. But of course, that doesn't include possibly first instance cases that weren't appealed. But in terms of cases that have been the subject of appellate review, 30 years. So therefore, it'll be said against me, well, 47 years or 50 years, depending on which way you look at it, on any view is significantly longer than those, although I would say it's not life.
So it's descriptive of sentences before the Court of Appeal?
Yes, and therefore it's guidance in that sense, because any judge that's planning to go beyond that is going to think to him or herself, hang on a second, that would be a long sentence. My Lords, just very briefly, one of the life sentence cases is at 1719, tab 30, 1719. Yes, 719. Well, as we can pick it up at 1720, paragraph 3. On 2nd August 2006, following a 3-week trial before Isaacs J. and a jury, Kendon Brown was convicted of manslaughter in respect of the death of nurse Joanne Lunn and the attempted murder of Anthony Saunders. Paragraph 4, on the next page, he was sentenced to life imprisonment in respect of each conviction, presumably to run concurrently, although there was no appeal against those sentences. And the facts, essentially, it seems, were that Mr. Brown had been sent in to do away with Mr. Saunders, who was in hospital, to finish him off, I think, is the way it might be put. And the nurse gets in the way and is killed. And he gets life for that, although there's no appeal against that sentence. And at paragraph 43 in the same decision, the Court of Appeal says we make no pronouncement on the sentences because there's no appeal. But that's one of only 2 examples, I think, or 3 examples, actually, I think, is Farrington, but that was also overturned later on a procedural irregularity point. But, my Lords, the simple point, I say, is that this case is closer to that sort of case than it is your average manslaughter case, where a fight gets out of hand, or there's an accident, or there's some unlawful and dangerous act that causes death. Because you do, at the very least, have a deliberate and callous act of arming with that powerful weapon and shooting at close range into a wooden house where people live. That is an extremely serious offence and stands in contrast to the sorts of offences for which lower fixed-term sentences for manslaughter were imposed. I'm literally going to be 2 minutes. The only thing I wanted to do, and I accept it's necessarily broad brush, but those acting for the appellant have kindly put together a table of sentencing cases. It starts at 879. And all I'm doing is focusing on the ones where a fixed term sentence of at least 25 years or 30 years was imposed. And looking at the brief facts And we can start at 879 with the case of Mr. Edgecombe. Following a disagreement, D had been hit over the head by V with a bottle, causing him injury. Later, D armed himself with a knife and stabbed the victim. Both went to hospital. The victim died. 25 years. Of course, that has to be compared with this case, where you've got an entirely innocent victim. Wasn't involved in any form of violence towards the defendant. Wasn't involved in any form of altercation that went wrong. No provocation. Absolutely nothing to do with it. In my respectful submission, it's obvious that this case is much worse.
Can I ask Mr. Penningham-Benton for what purpose you're taking us to these comparators?
For the purposes...
Because if this matter, if this sentence is to be quashed, one issue will be whether it's appropriate for us to deal with the precise sentence that should be imposed, or whether it's a matter that has to be remitted to the Court of Appeal in the Bahamas.
I've slid into ground 5,
Right.
which is manifestly harsh. Basically, I'm saying, well, my main submission on grounds 1 or 2, procedural irregularity, not hearing from counsel, etc., is we don't need to because you've already got the reasons. You can apply them across from the trial judge. And actually, the sentence of 50 years, if you accept that the reasons of the judge can be applied to the scale of manslaughter offences, actually isn't unduly harsh because it's much more serious than all of these offences. So that's one.
Well, before you leave one, if you analyse that case, it was an intention to cause grievous bodily harm. So he had an intention, and most certainly was reckless when he put a knife into somebody, severed a vein and artery, and let him to slowly exsanguinate. So he had two things. He had an intention to cause grievous bodily harm, and he was reckless.
Yes, that's right.
Yeah.
But what he didn't have was...
and in this case, we have recklessness.
Well, you have an intention. The unlawful and dangerous act there is arming yourself with a high-powered rifle, isn't it, and shooting at close range into a house, reckless as to whether or not somebody's there they're going to be killed. That is not an intention to cause GBH. But on the other hand, you have an entirely, as I said, an entirely innocent victim, no provocation, an act of cold revenge as opposed to reacting on the same day. In terms of moral culpability, the judge's reasons take this case, in my respect, submission far above a victim hitting someone with a bottle and then getting stabbed. It's just not this case. It's nowhere near this case. And then on 883, Emmanuel Roll, 30 years after a fight in a bar, D left and obtained a shotgun, returned and opened fire in the bar, one of whom died. There's no home invasion, there's no child involved. Years is the starting position for that. And then
he killed 3 people, Mr. Baker.
Sorry?
Injured.
Injuring 3 people.
Injured 3 people, but killed 1.
He formed an intention. He had time to think about it. It was premeditated. He came back with a weapon. He opened fire, and
well, it can't be a murder, otherwise it would be a murder case.
Well,
He can't have been sentenced on an intentional basis.
Well, then he was extraordinarily reckless as to what he was doing.
Exactly. That's this case, my lord, precisely my point.
Yeah,
you don't fire a high-powered weapon capable of firing up to a mile, spraying a wooden house full of bullets.
Well, you don't go into a pub.
Don't get much more serious than that, in my respect.
Well, you don't go into a bar with a shotgun and start opening fire on people.
Yes, and worse here is it's in a home and a child dies. 2 aggravating factors that easily whip it over the 30 years. Easily. I think I will do with the other ones. At page 890, the case of Gibson.
So
890.
90, yes.
This is the case of the defendant being found liable for manslaughter on the basis that the co-defendant had a knife and killed somebody. 30 years, and he didn't actually even inflict the injury himself. And 890.
It's not entirely a satisfactory case because apparently the appeal against conviction was allowed.
Yes. I'm just looking at sentences, though, for the purpose.
I'm sorry?
I'm just looking at sentences.
Well, I appreciate that, but in a case where there shouldn't have been a conviction in the first place, it's not perhaps the soundest place to find useful guidance on sentence.
Fair enough. And then 892, the top case, Francois, that's another conviction allowed one. And then you've got the 2 life imprisonment cases on pages 894 and 895. It's obviously, I can't, if I don't get home on my point about reasons being transferable across, then obviously I can't cut from cold support the Court of Appeal's decision for 50 years by reference to these cases. But all I'm saying is that if I can transfer the reasons across, and if your lordships are satisfied that the Court of Appeal was entitled to say, as unanimously it did, that this is a case that stands at the top end of the scale for manslaughter, then that is where the top end of the scale is. It's above those cases. And there's nothing irrational, if I can put it like that, about that determination. Or except I can't re-sentence on the basis of those. Lords, I'm grateful for your patience. I realise this is obviously a very difficult case, and those are my submissions, unless I can assist any further.
We'll rise to see. Thank you very much. Mr. Taylor, the board is minded to advise His Majesty that the appeal should be allowed to this extent, that the sentence should be quashed on ground 1 in relation to the failure to give reasons and the failure to give an opportunity to address the court. In addition, of course, I think it's ground 4, failure to take account of time spent on remand is conceded. We are not minded in the judgment which we will produce to say anything about the other grounds. But should you wish to address us on those other grounds, this is your opportunity.
My Lord, thank you very much indeed. Could I just take a moment to...
I'm not necessarily inviting you to do that, but I'm providing an opportunity.
I'm grateful.
Indicating what our provisional view would be.
My Lord, I'm very grateful. It seems to us that the additional grounds can be dealt with at any resentencing hearing, and therefore I'm grateful to your lordships, but we won't seek to address you on those points.
Thank you. In that case, I should say that the board is very grateful to all counsel in the case, and we will in due course advise His Majesty that the appeal should be allowed and the sentence quashed on ground 1 and on ground 4, and the matter remitted to the Court of Appeal of the Bahamas for resentencing hearing.
Grateful. Thank you.